Hello, thank you for joining our second series of the Immigration Law mini series Lunch and Learn overview. Today's session is entitled Why Don't They Just Come Legally? Immigration 102, Humanitarian Migration, Humanitarian Pathways, and the Border. Today we have a number of distinguished presenters. Tracy Harper, who's the Afghan Program Managing Attorney at Catholic Charities of Denver. Emily Smith, the Asylum Program at the Catholic Charities of Denver. McKenna Newsom Schonenberg from JAMLAC. And Ashley Harrington, the Children's Program Managing Attorney from the Rocky Mountain Immigrant Advocacy Network. We're thrilled to have you all today. For those of you who are new this week, this series is answering a lot of frequently asked questions that service providers in Colorado have, well-meaning Coloradans who are not involved in refugee and immigrant services have, because as new populations enter our state with varying legal statuses, those of us who are engaging refugees and immigrants have questions that should only be answered by attorneys. And we want to know how to understand the immigrant situations that we find our friends in, and also sort of what steps can be taken to help them in their immigration pathway. I will just make a note that you can choose to pin your screen if you are not thrilled with how it's displaying. So you can either pin the slides or pin the person who's speaking. We have a lot of content to cover since we are covering so many different humanitarian statuses and kind of ways that individuals enter the country. So we'll be taking Q&A towards the end of the presentation to allow our presenters the most time for content. And then just also as a reminder, this presentation is for general content and awareness. It's not a venue to ask case-specific questions. So our team of presenters is going to ignore any case-specific questions because it's not ethical for them to provide case-specific guidance in this setting. So with that, I'm going to turn it over to Tracy Harper to give further disclaimer.
Hi, everybody. As Mary said, my name is Tracy Harper. I am the managing attorney at the Afghan program at Catholic Charities of Denver, and I also run our TPS project. I'm going to start us off with a couple of disclaimers, and then you will see and hear me in and out throughout this entire presentation. The first disclaimer is about information. This presentation, all of these presentations are informational purposes only. We are not here to train you to provide these services or to know all the ins and outs of immigration law. We want to make sure that you have the information to make good referrals for your clients that you meet in the community. The second one, Mary, can you change the slide? I don't seem to have permission after all. The second one is for any of our service providers out there who are also part of the immigrant community. This, again, is informational purposes only. We are not here to answer specific questions about individual cases, either for anyone here connecting with us or working with someone who is not here today. Any case-specific questions need to be talked to with a lawyer in their office. And then my last piece here at the beginning is just an overview of the topics we're going to cover today. So I think personally my favorite two are the first two that my colleague Emily Smith is going to cover, and that is what are the forces behind migration to the US, what's going on at the border, what's parole, and then what are some of the different pathways that people who have made their way to the US have access to so that they can stay here. As well as refugee status, which I'm sure a lot of you are already familiar with. And I think now we are going to turn it over to Emily, and she will cover the next section on the border.
Mary, can you advance the slide, please? Uh, Good morning, everyone. Thanks for being here. And thank you for all of your work that you've been doing in the past year and a half. I know things have been very different for social services providers, been very stressful. Um, Large numbers of new arrivals in our communities. And a lot of people have been asking and wondering who are these new arrivals? Where are they from? Why are they coming? Why are they coming so much now? And part of it is that there have been large immigrant flows in our community before that maybe social services providers haven't seen as much of because people have found their own housing and they've found their own roots into the community. But no one can deny that we've had large numbers of new arrivals lately, and a lot of that has to do with what's going on in the world around us. Everyone is aware that we've received tens of thousands of new arrivals from Venezuela. The country of Venezuela has had a lot of difficulties in the last decade due to their own political situation. Their economy has really collapsed. It's become extremely difficult for people to access the basic necessities of life, food, their medical care, or uh, very little in the way of jobs or economic activity for people. And then on top of the economic situation, there's the political situation continues, in that anyone who opposes the government for all of what's going on is being severely persecuted by the government. We've seen a lot of Venezuelans who are arriving who have been unlawfully detained and even tortured by agents of the government. So we have seen a lot of folks coming from Venezuela. We have always had a lot of immigration to the United States from our neighbor country of Mexico and from the Central American countries. We've had a lot of immigration from those areas in recent times due to the movement of drugs from South America through Central America and Mexico to the United States. That's created powerful criminal organizations that deeply affect the daily lives of ordinary people in Mexico, Honduras, Guatemala, El Salvador. Um, so we continue to see large amounts of migration driven by violence caused by street gangs, narco trafficking gangs, narco trafficking cartels. Um, we've begun receiving more than in the past migration from the South American countries other than Venezuela, including Colombia, Ecuador, Peru. We've seen a lot of immigration from those countries. Again, much of that is driven by criminal violence, as there has been a huge displacement of Venezuelan people throughout South America. Whenever there's a displacement of human beings, we're going to see a rise of human trafficking. Human trafficking organizations operating throughout South America have been a major push factor. Criminal organizations trying to recruit young males, trying to sexually traffic young females, are driving the youth and their parents and families to flee from that situation through the dangerous situation in South America and Mexico and to the US southern border. We're also receiving large amounts of immigration from outside of our own hemisphere. The situation in Afghanistan, we were involved in a military operation in that country for many years. When we withdrew, there was a massive collapse of the interim or US supported government there. People who collaborated with the United States during those years are in great danger there for being seen as traitors or people who are a danger to the acting Taliban government. And women in that country are all in a lot of danger. Another large community that arrived in Colorado this year were Mauritanians. These are folks who are from a northern African country where slavery and race-based caste systems are still a driver of great violence. There are a lot of complex historical interactions between the communities in Mauritania, which include Arab descended peoples of lighter and darker skin tones, as well as sub-Saharan African people of dark skin tone. Many of those folks are experiencing severe racial discrimination and even forms of modern day slavery that people are escaping from. We saw within the last 2 years the outbreak of war in Sudan again. This is also driven by racial discrimination, conflicts between Arab and non-Arab people. We've seen large numbers of Sudanese arriving to Colorado, and that is just a sampling of some of the major issues that are driving people to the United States southern border. We could go on for a long time. Sure, you guys are all meeting people from different places and learning about different countries and their situation. Never hesitate to educate yourself about the news in the countries of origin of the people who are arriving in the United States. Mary, could you advance the slide, please? So we have many, many, many people arriving in the United States. What happens to them at the United States border? Social services professionals, we often meet people who have big packs of paper. What is in those packs of paper and what does that reflect about what happened to them? There's a couple different ways to make it across the United States border. Something that's important to keep in mind is how incredibly dangerous the US southern border is. Drug trafficking cartels and human smuggling operations have a significant foothold there, a lot of control over the border areas, okay? So this is a very dangerous place for people to be. And we have a lot of families arriving and young people unaccompanied arriving at the United States. So they're coming through a very dangerous gauntlet. One way of entering the United States is through a port of entry. These are places on the border where there are actually bridges across the Rio Grande River, actual border stations where you can drive or walk and have contact with a Customs and Border Protection agent of the United States government. They release an application on people's phones called CBP-1, Customs and Border Protection 1. People can request a chance, a time of day to present themselves at a port of entry. If they do that, they will be paroled into the United States, and we'll talk a little bit more about parole in a moment. It's not a permanent legal status, it's a marker of a lawful entry. But it's not that easy. I've met many people who have been trying on their phones to get an appointment through CBP-1, and they may not be able to even get through, may not be able to get an appointment, may get an appointment that is 3 weeks from now, which leaves them in a dangerous place with their children at the northern Mexican border, waiting for 3 weeks. I've met people who have gotten an appointment, then been kidnapped by cartels and managed to escape and ran straight across the border without waiting for their appointment. Because why would you? People who do not enter through a port of entry, people who enter without inspection, we call them EWIs in immigration law for abbreviation. People who enter without inspection and who are apprehended. This is very common. Many people will purposefully cross the border and turn themselves into the nearest Customs and Border Protection officer they find, wanting to enter some sort of regular process to the United States. They just weren't able to get an appointment to cross at the border. So these are people who enter without inspection, but then are apprehended or turn themselves in to border officials. They are usually taken through a number of different types of processes depending on their age, family status, and many are released into the United States with a notice to appear in immigration court. That means that they're going directly into deportation proceedings. There's a very small number of people that I've seen who the last category would be people who are entering without inspection and not being apprehended. I very rarely see that compared with the past. The only people that I've met who entered without inspection and were not apprehended are single adults. I haven't met families who managed to make it all the way across the desert with small children and not be apprehended by Customs and Border Protection. So I very rarely meet people who are in EWI without apprehension, but those are the people that you might find are very difficult to serve, or are you're not permitted by your grants to serve them because they do not have an A number, which stands for alien number, which is a term we don't really prefer. A DHS registration number, we also call it. People who enter without inspection and who are not apprehended, they do not have an A number. People who enter without inspection and are apprehended and are placed into removal proceedings, they do have an A number. And people who enter through a port of entry with the CBP1 app and get parole, they do have an A number. So what is parole? It's important to understand that regardless of, even if you enter through the border at a port of entry and you are allowed to enter, or you're apprehended and you're allowed to enter, that still doesn't mean you have a permanent legal status. We're just talking about your manner of entry here. The fact that you had a lawful entry doesn't mean you have legal status in the United States. And I realize that can be kind of confusing. Parole comes from the French word for word. It means you're being allowed in on your word rather than on a bond. So it's like you're being released on parole instead of released on a bond, paying money. The border officials are exercising their discretion to allow you to enter. Usually they are placing people directly into deportation proceedings upon allowing them to enter. And usually they are giving them this parole status for 1 to 2 years is the maximum that I've seen. And the shortest I've seen is 60 days. So parole is kind of a marker of a lawful entry, but parole is not itself a permanent legal status. I think of parole as a bridge. Parole is, we're going to get you from the border where you entered to the community where you're going to settle. And when you get there, you've got to then go ahead and apply for some kind of permanent lawful status, like asylum, special immigrant juvenile status, special immigrant visa, or all of the things that my colleagues are about to talk about now. So once you've made it in, then what do? What are the pathways available to a long-term lawful status in the United States? Tracy will start by talking about temporary protected status.
Really quick, can we go back to the last slide? I have one really quick point I want to make. One thing to know about parole is that parole based on a humanitarian basis does allow the parolee to apply for a work permit. It is a very, very temporary benefit that it is valid only to the extent that parole is valid. So these like 60-day parolees that Emily have mentioned, by the time their application is processed, they no longer have parole. And so that work permit is basically useless. The city of Denver has been doing, and JAMLAC have been doing these work permit workshops to assist with that process with a lot of our new arrivals who are parolees and have eligibility to work based off of that. All right, temporary protected status. I have become an expert on this topic in the last 6 months. Temporary status is very similar to parole in a lot of ways. It is permission to stay in the United States. It is permission to work. It is nothing else. It is not a path to a green card. It is not a path to citizenship, and it does not last forever. Generally, we're looking at an 18-month designation. Temporary protected status comes from the executive branch of the U.S. government. The president and his executive authority will look at the situation in a country and say, this place, the people from this place really need to be protected so they don't have to be sent back. For example, Afghanistan, Venezuela. In total economic and political collapse, right? A government that is now a terrorist organization. Massive earthquakes or hurricanes. Those are the sorts of things that encourage the executive branch to say this country should be designated for temporary protected status. Information about that is really, really easy to find on the USCIS website. So if you're interested in looking more into who's eligible and when they're eligible, that's a really great place to look. And now we are going to talk a little bit about all of our humanitarian pathways, the big ones that we as practitioners see and use all of the time. We're going to start with refugee and asylee status because these are two that are very similar but often confused. And so we just kind of want to give you guys the spoiler alert to what is the tiny difference between these two statuses. The legal basis for both of these statuses is exactly the same. One either has to have suffered or have a well-founded fear of suffering persecution based on a specific reason. A few slides down the road, we'll show you exactly what those reasons are. But the main difference between being a refugee and asylee is where you apply for this status. Refugees apply for refugee status outside of their home country, but in another country besides the United States. And through the UNHCR, they are processed, granted their status, and then resettled in a country. Asylees can only apply for asylum in the United States. You have to be at a port of entry or your feet have to be on US soil for you to be eligible to apply for asylum. So nobody outside the United States can apply for asylum, just as nobody inside the United States can apply for refugee status, but basically they are identical statuses with slightly different benefits after they've been received. One thing to note is that both of these are pathways to a green card. In both cases, after having that status for a year, the individual becomes eligible to apply for a green card and work their way on the stable sort of journey of immigration in the US and ultimately get to citizenship eligibility as well. Very, very long and complicated definition of refugee. This was first defined in 1951 and is basically still the definition we use today. I'm not going to read this out for you, but the things that you need to be really paying attention to are they're outside of the country where they have experienced or fear persecution. They are unable or unwilling to return to, or unable or unwilling to avail themselves of the protection of that country. And they have been persecuted or have a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. These are just words. The law itself is incredibly complicated. This is the death penalty law of immigration. The people who are working within this legal definition are dealing with life and death on a legal basis. And then I kind of want to let you talk about asylum. Emily is our expert asylee person, so I'm going to just let her talk to you guys about that real quick.
So remember that Tracy said that if we're talking about the same definition here, people who are in danger in their home country because of their political opinion, race, religion, nationality, or membership in a particular social group. But the refugees have already been processed in a third country. They come, the refugees come to the United States with refugee status. They're already safe. They already have the status. Asylum seekers are people who feel that they can meet this definition, meet the definition of a refugee. That is someone who fears persecution for their politics, race, religion, nationality, but who did not get processed somewhere outside the United States. They had to touch land in the United States and say, process me here, find that I am meeting the refugee definition here, and make me an asylee, okay? So asylees have to meet the definition of a refugee, but they have to meet it here. So something that is really important to understand about asylum is that it doesn't protect you from a lot of the things from which people come to the United States seeking protection. Poverty, generalized crime, starvation, lack of medical care, being unable to grow crops in your area because the environment is falling apart. None of these are in the refugee definition. Now, we're all making these arguments. We're trying hard to find a way to package the experiences that people are having and shoehorn them into this refugee definition that we've had since 1951. But that's very difficult to do. One of the questions is, where's gender? I don't see gender on here. It's not on here. We have to argue that as a particular social group. So that is a really important thing to understand about asylum status is that it doesn't just protect you from anything you fear. In addition, you have to show that your own government can't protect you. You have to show that you couldn't have just gone to a different part of your country to get away from the danger you faced. You have to show that one of the countries you passed through on the way here didn't already give you a stable status. And you have to show that in legal terms that you're not barred. And in general, we kind of wrap that all up into saying that you're not a problem for the United States. We want you to come and be protected here. Us protecting you isn't going to cause a problem for us. But I think the most important thing to understand about asylum is that it's not for everything. It's not for great poverty. It's not for fear of crime. People want to tell you how horrible these gangs are that were extorting them. And that is absolutely true. And they have every reason to be afraid. But that is not in the definition of a refugee. And so lawyers have to argue very hard to find some way to get that in there. That's an important thing to think about asylum.
All right, and then I'm gonna very briefly touch on special immigrant visa status. So special immigrant visa, the special immigrant visa is a program developed to support individuals in Iraq and Afghanistan who supported the U.S. military operations, either through being interpreters and translators and community bridges with the communities in those countries, or working on the ground as contractors, logistics operators, working at the embassies, like everything from painting and carpentry up to, providing security at the government buildings in those countries. It's much more complicated than looks on these slides, so I apologize that if anyone out there is actually a member of this group, I hope I did not reduce it to much smaller than it is. So the requirements are that they have to be a national of Iraq or Afghanistan and worked for at least a year as either an interpreter with the U.S. military or as a contractor with the U.S. government in Iraq and Afghanistan. Eligible translators have to have a favorable written recommendation from a specific supervisor in order to receive the status, and eligible contractors have to have a letter of recommendation from a supervisor, and also demonstrate that they experience and will continue to experience an ongoing threat as a result of the employment with the U.S. military or as a contractor to the U.S. military. It is currently a two-step process, although it used to be a three-step process. The first step is applying for a chief of mission, which is that first step that I just mentioned for the translators and the contractors. Once that's approved, if the applicant is located outside of the United States, they would apply for an immigrant visa to come to the U.S. and they would arrive with a green card. With the large evacuations from Afghanistan in 2021, we ended up having a lot of SIV eligible Afghans here in the United States, Colorado included. And so the sort of process changed a little bit. And so anyone who arrived in the US through the parole process, who had their COM approved after they arrived, they were able to apply for adjustment of status here in the United States and receive their green card that way. Let's see. I think this pretty much sums up everything I already said. Yeah, so I think we can move to special immigrant juvenile status, and we will go off camera for a little while so that our colleagues can present on their topics.
Hi, y'all. Good afternoon. My name is Ashley Harrington, managing attorney of the Children's Program at Remain, or the Rocky Mountain Immigrant Advocacy Network. Thank you all for being here this afternoon. So I'm going to talk to you all about a very different kind of pathway towards a green card, or pathway towards lawful permanent residency and eventual U.S. citizenship, but that has a similar name to what Tracy just covered. It is special immigrant juvenile status, but this is really, really different than the special immigrant visa that Tracy just covered. So the key word in here is juvenile. This is a pathway towards a green card, or pathway towards permanent residency for children. And the way that children is defined under the immigration law is under 21 and unmarried. So this is only an option for folks that apply while they're under the age of 21 and while they're unmarried. Who is this pathway for? It's for certain abused, abandoned, or neglected children. So children that have suffered parental abuse, abandonment, or neglect by one or both of their parents. So to give a few examples, maybe a child has been raised by a single mom and doesn't even know who dad is. Maybe child was living with dad in home country, and then he passed away, and therefore the child was abandoned through father's death. Those are just kind of a couple of examples. So certain youth who have suffered parental abuse, abandonment, or neglect that are under 21 and unmarried. And it's a two-step process, really, to apply for special immigrant juvenile status. The first step is that the youth needs to get under the jurisdiction of a state court that is willing to make a custody decision or a guardianship decision, or perhaps like a dependency and neglect decision for our foster youth. It's a court that will have jurisdiction over that child or over that youth as a child under state law, and will make a custodial placement of that child. So some more examples. Maybe child came here by themselves, came to the US border alone without a parent, and then they were placed with dad here in Colorado. Mom abandoned the child a long time ago. They don't know where she is. She took off, years ago. I don't know, I'm just making up case examples. But dad could file a petition for custody over that youth, and that would put the youth under the jurisdiction of a state court. And if that state court made a decision to place the youth under the custody of dad, that's the kind of court that we're talking about. And then that court needs to make some additional findings in addition to the custodial placement or placement in guardianship or placement in foster care. That court needs to make a few other findings. First of all, that reunification of the child with one or both parents is not viable due to that abuse, abandonment, or neglect, and that it wouldn't be in the child's best interest to be returned to home country, that it's in their best interest, sticking with the same case example, in the child's best interest to remain here in Colorado under dad's custody, where the child is well cared for, is attending school. It is not in the child's best interest to be returned to, let's say, Honduras, where the child had no caregiver, where they were unsafe, where they were being recruited by gangs, for example. So youth under the age of 21 and unmarried who are able to get a court order placing them in the custody or guardianship or foster care, basically a placement with an adult to take care of them. And then that court finds that they cannot be reunified with one or both parents and that they shouldn't be returned to their home country. If you get that court order from the state, you can then move on to step 2, which is applying for special immigrant juvenile status with U.S. Citizenship and Immigration Services, with USCIS. Actually getting designation as a special immigrant juvenile is relatively quick in the realm of immigration law. It generally takes about 6 months to be designated a special immigrant juvenile. At that time, typically you're also granted deferred action, which can get you a work permit and social security card. But then the wait will be very long for those youth to be able to move forward with the final step of applying for a green card or permanent residency. We have a massive backlog, and only so many youth are allowed to move forward with permanent residency on this pathway each year. And so at this point, it is likely to take 6 or 8 years for youth to be able to move from being approved for special immigrant juvenile status to being granted a green card or permanent residency in the US. But they're on that pathway. They have a work permit, a social security card, and generally can get out of deportation proceedings if they're in deportation proceedings while they wait to be allowed to move forward and apply for a green card. Special immigrant juvenile status is the bulk of what we do at Remain. So if folks have questions about special immigrant juvenile status, Remain Children's Program would be a good resource, as well as my colleagues at JMLAC who are also here. And then I'll just take probably 1 minute on the next slide for DACA. DACA was a program that was started under the Obama administration because there was no movement in Congress to pass what was called the DREAM Act, or some kind of pathway towards permanent residency for dreamers or for youth that were brought here to the United States as very young children who have attended school here in the United States for many years. Congress has still failed to pass any kind of DREAM Act for these youth. And so it was basically an executive program by the beginning with the Obama administration to allow those youth to get something kind of similar to TPS, temporary protected status, that my colleagues talked about. It's basically just a temporary way to have a work permit, relief from deportation, and that you need to continue renewing every 2 years. It is only for youth that have been here in the United States since 2007 at least, and that came into the United States before they turned 16. And at this point, the only people who are eligible for DACA are those who have already been granted DACA and are now wanting to renew that protection. Due to ongoing litigation, at this point, you can actually submit an initial application, but no decisions will be made on initial applications. The only folks who are eligible to continue applying for and having decisions made on their applications for DACA are renewal applications for those who already have or had DACA in the past. All of this area of the law is very much up in the air and in flux. We do expect a Supreme Court decision related to DACA likely later this year. And I will pass it on to my colleague now. Thank you all so much.
All right, thank you, Ashley. I am McKenna Newsom-Schoenberg, and I am an immigration attorney at Justice and Mercy Legal Aid Center. Thank you all for being here this afternoon. I'm going to briefly talk about U visas, commonly called a U visa, but it actually stands for U non-immigrant status. This is a pathway to residency and eventually to citizenship for people who are victims of certain qualifying crimes, who reported that crime and cooperated with law enforcement, maybe subsequently a district attorney's office, city attorney's office. So the requirements are that you must be a victim of a qualifying crime. The qualifying crimes, there's too many to list on this one slide, but at the USCIS website, if you Google USCIS U visa qualifying crimes, you'll get the list. And so you must be a victim of one of those crimes. You must have suffered substantial physical or mental injury. So meaning, you know, obviously if you're a survivor of domestic violence and you can show physical harm that you survived, that works. But as well as if you're, you know, a survivor of domestic violence that maybe has a lot of layers to it, there's emotional abuse, and there's also financial abuse. It's difficult to show those things in like a document sense, but you know, a lot of the times we have folks write victim statements that they can detail the injuries that they've suffered, and that's one way to prove those things. You also must prove that you've been helpful in the investigation and or the prosecution of the crime against you. So a lot of times victims in the state of Colorado are sent letters or emails from the district attorney's office, the city attorney's office, law enforcement, showing, you know, communication, being updated about a case that's happening, going to photo lineups and trying to help there, speaking with the police when the police call. Those are all forms of being cooperative, being helpful. And so in order to qualify for a U visa, one of the requirements is that an attorney or somebody, the victim themselves, could prepare this. It's called an I-918B. It's a supplemental form as part of your U visa application packet. And that form actually goes to law enforcement or a district attorney's office, city attorney's office. A few other agencies can also sign those. But it's a request essentially for that agency to sign off that the person who is the survivor of the crime was helpful. With that signature, you're eligible to continue the rest of the U visa application. Without that that supplemental piece of information, that supplemental page, I should say, signed, you are not able to move forward with the U visa application process. So that's really important. The really tough thing about the U visas is that right now right now the US government is only adjudicating about 10,000 applications per year. While that sounds like a lot, it is just not enough. The backlog is, it's a lot. There's a lot of people waiting as U visa, I guess the information about U visas has spread about to people, and then also just more people applying. And so currently the wait time in terms of getting a decision on your U visa application could be up to upwards of 16 years, which is a long time. In the meantime, though, folks can receive deferred action while their U visa applications are actually pending. And there is such a thing as a bona fide determination, meaning folks who have submitted their U visa applications and on their face, they look complete. They can get, and they're not some sort of security threat, those applicants can get a work permit during their wait time. It is not guaranteed. It is up to the discretion of USCIS officers, but it is something that potentially they could get during their wait. Can go to the next slide. Great. There's also such a thing as a T visa, T non-immigrant status, and T stands for trafficking in this case, and this is for victims or survivors of severe trafficking, and it is distinguished or separated into two groups. There's sex trafficking and then there's labor trafficking. Okay, regardless of whether or not a person is, depending on the kind of trafficking that they're applying for, the eligibility requirements remain the same. So you have to be a victim or a survivor of a severe form of human trafficking. A lot of these words are vague. That's why it's really important to, as best as people are able to, get connected with attorneys who are able to kind of help them make their case. But be a victim of a severe form of human trafficking. You have to be in the United States because of that trafficking. That doesn't necessarily mean that you have to have been picked up maybe at the southern United States border and then taken over, our country lines because of trafficking. But you have to have, that could obviously be one case, but you could also be in the United States and you're kept here because of trafficking. So if you move to Colorado from Mexico, seeking a better life, and then you start working at a company, and now the conditions of your employment have changed. You're being, maybe it's turned into some sort of indentured servitude or something like that, and so you're having to remain in Colorado because of this employment. That could potentially also be human trafficking. So again, just really important to talk to attorneys if you have cases like this come up, so that people can try to navigate whether or not you are eligible and then how to make that case. You also have to have cooperated with law enforcement to report the trafficking that you have survived. You can do that. You have to do that prior to applying, but an attorney could also help you with this if you haven't already reported it yet. Your immigration attorney potentially, depending on what their limitations are, but could try to help you report this trafficking to government officials. Additionally, the final requirement is that you have to show that you would suffer extreme hardship if you were removed from the United States. So there's a bunch of different factors that can help reinforce this. But, if you have 5 children who are all under the age of 10, who are all US citizens and going to school here, and they don't have another parent who's here, they don't have family who's here, that could be one factor in terms of you're trying to support your family. And if you left the United States, that would impact these 5 little kids. Something like that, as an example. The cap on the T visas is at $5,000 per year. And so right now, last time I checked, that cap had never been reached. So if somebody doesn't qualify for a T visa because of sex trafficking or labor trafficking, this could be just an option that is maybe a little bit faster if they do qualify for them to go through the immigration process. Something to consider. Thank you. And then I'm going to pass it on to my colleague as well.
The title of our presentation of this segment is, why don't they just come legally? This is a question that we receive so many times. And you've just had an opportunity to hear about some of the lawful pathways within the United States. And what you may have noticed is that a lot of them are dealing with issues in which a person can't cross the border lawfully. So this is someone who's being trafficked over our border. This is a young person who's arriving unaccompanied, having been abandoned by their parents. This is a situation where someone is fleeing from being persecuted, being tortured. So these are not folks who have a lawful US citizen relative and they're going to wait in the 15 to 20-year line to get a green card and enter lawfully. These are not folks who have a US-based employer who is going through the employment-based immigration process for them to have a green card when they enter. So a lot of these forms of remedies are for people who are forced over the border in situations of extremis and of distress. And another response to the question, why don't they just come legally, is because there may actually be no lawful immigration status under US law for a person. There may be simply no status for them that addresses the drivers that brought them here. I think something that I have to explain frequently is there's no just wanted a better life for my children visa. When we think about prior generations of immigrants, my grandparents and maybe some of yours, many people came to the United States seeking a better life. And I still meet hundreds of people who came to the United States seeking a better life, and there is no lawful status for that. It's something we've always wanted in the United States. It's something we've always had in the United States, but there is not a lawful pathway for that. And that's important to keep in mind. So Tracy's going to talk a little bit about unauthorized practice of law, just because we know that you guys have been put in this position a lot of times in the last year and a half. You're working with people who are new arrivals to the United States, and they ask you, okay, what should I do? How do I get my immigration status? How do I get my green card? And we recognize that that puts you guys in a really difficult position. You want to help. That's why you have the social services jobs that you do. But we have these prohibitions under the law in Colorado prohibiting unauthorized practice of law. We don't want you guys to get in trouble. We don't want you guys to be prosecuted by the Colorado authorities. And we also don't want any harm to come to your clients that you're trying to help. So Tracy will talk about some sort of higher level definitions of unauthorized practice, and then exactly specifically what can you do and what can you not do, which I think is probably the most useful information that you guys are looking for. And then in terms of, you know, what can you not do? If there's things that you can't do, then where do you send them? How do you get them in contact with the organizations who are presenting today who can provide low cost or no cost legal services?
So this is my less popular presentation topic. I am not going to read this slide to you, but I'm going to highlight a few of the important pieces for everyone on this call who is not an attorney or a licensed in any way to practice law. So this is from a Colorado law. It's within the Colorado Rules of Civil Procedure about what is the unauthorized practice of law. So big things to know. It's when a non-lawyer, not a licensed lawyer, not a Department of Justice accredited representative, someone who is just not a lawyer or a representative authorized to practice law, exercises their judgment. That's a really important phrase, exercises their judgment. We have all been trained in the legal practice. We know as much as we can know, and it is our duty to continue to learn so that whatever we tell our clients is the most up-to-date and correct information. And so when we exercise our judgment, we have the judgment of experience and education. So unauthorized practice of law is advising about the effect of an action or decision. An example of this is everyone knows that if you apply for asylum, you can get a work permit. However, that is a piece of legal advice. If you say, hey, you should apply for asylum, you'll get a work permit that way. You're basically advising the effect of the action of applying for asylum. And guess what? All of that is way more complicated than what I just said. The next big one is advising somebody about their legal options or pathways. Today's presentation is a really good example. We kind of summarize some really great pathways for people to become legal permanent residents in the United States. However, those of us on the presentation today, we are authorized to provide information about these options or pathways. One of the ones that I've seen a lot is the difference between TPS and asylum. Deciding, should you apply for TPS? Should you apply for asylum? And how do those two intersect? That's a very legally complex conversation that I have at every TPS workshop that we provide at Catholic Charities. And that's just not something that your ordinary individual working with immigrants would have the expertise to advise on. Representation, that's a bit of a no-brainer. Acting and behaving, whether implicitly or explicitly, in a manner that conveys capability or authorization. That is a mouthful, but it is really important that the people you're working with don't believe whether you say something or do something or just make an assumption that's incorrect. That non-legal service providers, case managers, community navigators, ESL teachers, citizen teachers, it's important that you don't do or say something that makes our clients believe that you have the ability to advise, because they are always looking for advice. They're always looking for our guidance, because most of the people we work with are either desperate or, just trying to make a living, make their way through the United States. And so we have to be really careful when we give advice on anything legal. The last three are kind of not really, I don't think, that important for the topic of this conversation, but it's here if you'd like to read it. Let's see, next slide. Some of the big things that I see out in the community are, helping, okay, the second bullet point, drafting pleadings or other papers for any proceeding before any tribunal. This is things like filling out an immigration form for someone. The very most a non-authorized person could do is to literally scribe information into a form, the very most. You would not be able to say, you should fill out this application. That would be practicing law. You should not be able to say, this is how I think you should answer that question on this form. That is also practicing law. Is similar. Exercising legal judgment, taking information that you've learned today as you advise your clients on what to do with their legal matters. That would be considered practicing law. And then this last one is also really important. Any other activity the Supreme Court determines to constitute the practice of law. This is not an exclusive list. You could do something and then down the road get into a lot of trouble, and the Supreme Court will say, well, that is practicing law. Maybe you didn't know about it ahead of time, but the Supreme Court says it is. So we just want everybody to be really careful when you're talking about anything legal with your clients, if that is not your area of expertise and your area of licensure. I think I've already covered this, but I'll touch really quickly. The big ones, don't tell anybody, you should fill out this form. I think you're eligible for asylum. You should fill out the I-589 because that's the one I filled out for myself. Do not do that. Do not refer a client to a specific form. Showing them how to fill out a form. Again, explaining how to fill out a form, explaining what should go into a certain field. All of that is very legally complex. There's a note here that I think is really important. Every question on an immigration form is an attestation under threat of criminal sanction by the applicant, the interpreter, and the preparer. So if you sign or help someone fill out someone and they sign, you are saying under the penalty of U.S. criminal law, this is true. And I believe that it is true. And you just need to be really careful about doing that if that is not what you're licensed to do. And then this is my favorite slide because it's not telling you, no. It's saying, yes, do these things. These are the things you guys can do. If you're not licensed, if you're not DOJ accredited, help them change their addresses. It is a legal requirement that immigrants change their address with USCIS as well as immigration courts. The immigration court change of address, however, is technically a legal form. So I would caution everyone to stay away from that one because it requires you to attest that you have the capability and professional credentials to do that. And you have to serve it on the other party. And it's just much more complicated. The two big things, recognize when a client has a legal issue and don't solve it for them. That is really hard. We are all in this work because we want to help our clients. We want to help these communities. And so it's really hard not to try to solve all the problems. I have the same problem when someone tells me they can't find a job that's actually within their skill set. So don't solve that legal problem. And instead, direct your client to someone who can, someone who has the education, someone who has the licensure, the experience, who is a professional at that question. And then some other just sort of ones I threw in, help pay for legal services. I mean, sometimes the case is so complicated that it cannot be done for free. We all want everyone to get free legal services. That would be amazing. But sometimes you just have to pay. You have to pay for the expertise. So help fundraise for that when it needs to be done. Make a donation to a nonprofit legal service provider. Let me tell you, there's not that many of us here in Colorado. I think we all fit on a page of like one. And so we all need money. So if anybody wants to support the work that any of us here today or last week or next week are doing, we will take your donations. And then finally, write to your state and federal representatives. We are the people, we make the law, right? Like tell people what's wrong, what you're seeing, where are the service gaps, what can we do better? How can the state better fund this work? How can the federal government better fund this work? These are the sorts of things that we can say to our members of Congress all the time. And now I think we're on to questions. Okay, I'm going to sort through our questions that we've received so far. And any of our presenters, if you've got a question that you feel comfortable just typing in, feel free to answer. I'm going to be skipping the ones that are case specific and trying to summarize the ones that are similar into one or two questions. I don't think we can both at the same time.
No, that's fine.
I'd say I could just say yes.
Yeah, that's fine.
Just really quickly, Emily was about to type the answer. Filling out a change of address in immigration court is practicing law. Filling out a change of address before USCIS, which is just a form on their website, that is not practicing law.
There's a related question down below about a change of venue. A change of venue takes place in immigration court. Non-lawyers cannot file papers, or people who are not accredited representatives cannot file papers in immigration court. Remain has an assistance program at the courthouse that will help people fill out their change of address and change of venue. There are blank forms there that the clerk's office can help people fill out as well. We're seeing a lot of questions about helping people fill out an EAD application. That is Employment Authorization Document, also known as a work permit. Non-providers cannot fill out an EAD application. This is a form I-765. One of the most important reasons is because you need to know the category under which your client is eligible for an EAD and what are the requirements of that category. So that is definitely a situation of applying the law to the facts. Non-licensed providers cannot fill out an EAD application. If you're interested in doing that, I believe JAMLAC and the city of Denver are conducting workshops and clinics to help people apply for work permits. Please volunteer. You'll be under the supervision of attorneys and licensed practitioners there. Keep typing your questions into the Q&A, please.
Oh, wow. They're mostly gone. I see the unauthorized practice of law one has gotten everybody worried. That this is good. I don't want you to worry, but I do want you to worry because immigration status can be made or broken by the wrong people filling out forms. Even if your heart is golden as golden can be, and you just want to help people stay safe in the US, we get it. But we just need to make sure that the right people are providing that assistance.
One of the questions we have is, again, assisting people with the wrong address at USCIS. So if a person is, you can hit the answer live on that. If a person is, it's the third from the top, having trouble receiving their mail from USCIS, the people that we're working with are very transient. They may not have permanent housing yet. And that is really a lot of problems arise from the address. With USCIS, a non-practitioner can help someone fill out form AR11 online, the change of address. They can help someone call the 1-800 number for USCIS to get a past wrong document sent to the correct address, but the person has to be there and the person has to talk with USCIS. USCIS will not talk with you if you are not the registered attorney who has submitted what we call an entry of appearance, the thing that allows you to speak for someone with USCIS. So we're still seeing questions. Is it okay to suggest which form to fill out? And unfortunately, the answer is no.
You should not make any suggestions regarding immigration law unless you are a lawyer.
There are, there's a couple different pathways. This particular question is about when someone needs a waiver related to their citizenship. There's a couple different ways to approach that. You might need to do the medical waiver that a doctor fills out. You may be able to just request an accommodation. It would be great to just talk to a lawyer to figure out what the pathway is going to be. That will be careful. Anytime you're asking for a waiver with immigration law, you're saying that you don't have something that they want. That's something you want to be careful with, right? Because you might be inadvertently saying, oops, I'm not eligible for this thing that I just applied for. And I think that's allow me to give an example if I can. I don't know a lot about public benefits. Many of the people on this call know a lot about public benefits. I know what an immigration lawyer needs to know about public benefits, which is when are you a public charge? When do I need to disclose receipt of public benefits? When it comes to the nitty-gritty of who's eligible for a specific Colorado benefit, I don't know. So I don't advise people on that. What if I did that? What if I took your role and I told someone, oh my gosh, yeah, sign up for this and start getting the money. And then years later, we find out that they weren't eligible and the government slaps them with thousands of dollars of repayment. I've harmed someone by trying to help. And unfortunately, that happens on the legal side as well. I, as a licensed practitioner before the immigration attorneys, make mistakes. I always tell people, if the standard is perfection, I'll turn in my bar card right now. But the clients are protected from my mistakes. There are specific laws about unauthorized or ineffective assistance of counsel. So if I, their lawyer, make a mistake and do something wrong, they are protected by the immigration laws. Their case can be reopened, it can be fixed. Those protections do not apply to unauthorized providers. If a client's case is harmed and a client is ordered deported, and it was some unauthorized provider who really just wanted to help, there's not a lot of protection. That case now comes to me. And there's not a lot that I can do about it because I can't get the client those same protections for ineffective assistance of counsel because they didn't go to a counsel. They just sort of had someone else do it. Maybe they didn't even sign it. Maybe it was someone on the internet. Maybe they don't know. So please, we understand that you just want to help, and we understand that law is expensive and it's a real pain in the butt to find somebody. All of that is true. We're not denying any of that. The problem is, what happens if we make a mistake? This stuff is so complicated that even those of us who do it every day make mistakes. We need to make sure that the clients are protected from our very human mistakes. And unfortunately, the law doesn't offer the same protections for unauthorized providers as it does for authorized providers. So please don't go there if you don't know. We're going to be sending out all the contact information for all of our organizations. So if you have a client that you think is eligible for one of the types of relief that was mentioned, if you think you have a minor that might be able to get special immigrant juvenile status, please send them to Remain. If you have someone who is a victim of a crime committed in the United States, please send them to JAMLAC. Please send them to us and let us try to provide them with low cost or free services.
Thanks, Emily, and thanks to everyone who attended. We're going to end the webinar and we will send out those resources. Please join us next week for our last part in this series, which is how can I sponsor my family member? And that session will cover both family reunification pathways open to all permanent residents and citizens in the United States, as well as ones unique to those with refugee status. Thank you so much. Have a great rest of your day.